between the town of Multiborough, Tamworth, and Sandwich.
Yeah, so,
Courtney, did we get a map?
oh, I'm sorry.
Did you want it to ask?
And the new day,
Thank you.
Right.
Is everyone from Tamworth that was expected?
We're still missing Emery, but sometimes it's late, so.
So start whenever you want.
So, yeah, I don't want to,
And is there anyone else from Multiborough?
No, I'm going to get it. I do a short straw.
Okay, so we have perhaps one more selectman coming in. I'm Joanne Haight, I'm the chair of the Sandwich Select Board.
I'm Adam Hurd.
Caroline.
I'm sorry, what's your name?
Caroline. And if we'd like to go around.
I'm Charlie Smith, Town Administrator.
And I'm John Tallman, Chairman of the Board of Selectmen.
I'm Courtney Delaney, I'm the Town Administrator for Sandwich. Holly Cox, Administrative Assistant.
I'm Carl Bear, Select Board member.
Richard Doucette, Tamworth Select Board member.
Keith Snyder, Town Administrator for Tamworth. And I
And
live in Salem.
Steve Schaefer, Select Board.
Thank you. Okay, a couple of things. This is a work session, and we appreciate you being here. We're not taking public input for those of you in attendance. This will be a discussion between the elected officials and their representatives, town administrators, regarding the current status of the perambulation. And thank you all for being here. In the interest of being good neighbors, I think this is an important discussion. We've had a series of there was a meeting in July, but some things came forward that we thought after that meeting with, do we have a court date in September? Is it set September?
September, I believe. That's
Correct. As we move forward, I thought it might be beneficial for us to meet as individuals without the attorneys and see if there's a way we can reach a conclusion. As I understand it, we can't compromise. We have to make a decision one way or the other. That it can't be sort of a flip of a coin and you get this piece and we get that piece. So I'm hoping that we can have really a productive conversation about where we are in this situation. That began 2020, 21 when that survey was done. So I'm happy to open the floor, Courtney, if you want to just be prepared, because I know she's our keeper of information. So I'd love to hear from you folks.
I'll start off. Richard Doucette, Tamworth Select Board. Most of our Select Board is relatively new. I think all but one have only been in office for a year and a half or less. So this started before we got here. And the first I heard of it was with a very large bill from our attorney. And so we were curious about that. Maybe you had similar experiences, I don't know. I'm assuming your legal bills are similar to ours.
Well, I think, but we had an awareness of it.
Mm-hmm.
So when we voted, when that survey was presented to us, and I'm not an expert in anything. And the longer I serve as a selectman, I realize how few subjects that I will ever gain any expertise in. We deal with a lot of things. So as a board, and just like your board and probably Molten boards, we're all switching. I'm currently in my second term, so I guess that makes me a veteran of these boards. And we're all volunteers. But what became clear in terms of that survey is that statutorily we understood one thing, that as a select board we cannot change a town line. That is only can be done by an act of the legislature. And without question, we believed that the survey as presented shifted the town line. And through the help of residents and our attorneys, in 1803, the legislature of New Hampshire basically said, we need official maps and surveys. And we completed one in 1805. That map, or that survey, and the map that was created, is what we use to tax today. There's no question about that. But that survey shifts the southeast line of Sandwich. We're not talking thousands of acres. We're talking about a couple of hundred. But it is a change. And as a board, what we recognize is we're not given the authority to do that. And there's some history of going back. And I think if you've read the CPX letter, who is our expert, and you know that Mr. Nix is an attorney for the survey. He's probably the most prominent one in New Hampshire. So we were fortunate to be able to utilize his expertise. And in the information as this has continued, there's been nothing presented to change our belief that the survey as presented is inaccurate. And understanding it goes back to a period of time. And it's not a perfect date, but here we are. So we understood when we made that decision it was costly. We were hoping naively it would be about a $10,000 problem. It's become much more than that. And as we approach September and some of those things, we certainly said, is there a way for us to reach an understanding of what the outcome may be and to save ourselves all, hopefully, tens of thousands of dollars.
So it's your belief that the boundary shifted. That is not my understanding. It's my understanding that the three communities have agreed on the line for over 200 years, and then Sandwich didn't agree to the line 2 years ago. So I don't see it as, it's not my understanding that it was a change of the
I would
boundary.
say, Richard, the 200 years is not an accurate statement.
100, 150.
But even if that's the case,
Yeah.
so we've all agreed, and we were wrong. That doesn't make it correct today. And if we overlay the tax map, and I was unclear in our meeting before, the tax map in turn, you'll find out these things that you have 18 acres, but you really have 16. It's the boundaries. And the boundaries come from the 1805 survey. The survey that was presented for the perambulation does not match that line. And, I think the one document that I asked Courtney to prepare, and it comes from the expert from Moultonborough and Tamworth. And I assume you've all had access to the documents, that there is a shift. And if we accept this, we either have a piece of land in this corner that's questionable, like whose is that? But it is, as I said, kind of the simplest thing. Surveyors like straight lines. They like top of mountains. They like clear points. And we have the 1805 survey, which leads to our tax maps.
And I believe the tax map is not determinative, so it's not by no means, perfect representation, but it mirrors the fact that we believe at some point we all agreed to a point that was at the top of the mountain. Whether or not for 150 years that shifted, and we all agreed then for 150 years, the point is that we can't determine that through acquiescence. There's no shift of ownership there. That really is only the legislature.
So this didn't come from a landowner to the board. You decided yourselves that you needed to pursue this.
Well, one of the things you're required statutorily, though many towns don't, is the 7-year or 10-year cycle of regulation. I'm sorry? 7.
But this was acknowledged in 2011, and that perambulation was Tamworth, I believe.
Correct, because the
issue
between Moultonborough and Sandwich.
But my question is it the select board who originated this, or did the landowner come to you requesting it? Because we're trying to understand how it started.
Or even, we're not going to litigate right in this moment
Right.
the facts because it's so complex. And I'm not sure that our surveyor would agree that we've agreed on what that point is. That's why we're in where we are. But again, we won't solve that right here. I guess what I would like to know is almost so what? So, okay, so why does this matter
Well,
so much?
it matters because fundamentally, as a select board, under New Hampshire statute, we cannot change a town.
Well, right, but, okay, again, we don't agree that that happened.
Well,
But so let's for a moment, just bear with me.
yeah,
Let's say, you're right. What practical implication does that have for anyone?
it has to align.
Because when you accept a perambulation report, you're accepting that it is correct.
Yeah. It's,
So if you know that, or if you believe that it's incorrect, to accept something as correct and you don't believe it's correct is fundamentally, I think, the issue.
And we're trying to understand the ramifications, because as far as we can tell, at least financially, the ramifications are property that has little to no tax value, and we will,
Almost no timber value.
so it will take, we'll be all in this room long dead before enough tax revenue is gained by whoever gets extra land from it. So that seems like a real waste of public
I
funds
would say,
for tens of thousands of dollars when the tax bill is like $25.
I think that the clarity, it's not going to shift any of that because we're taxing on the 1805. So there isn't a shift in that because how we tax people, it's the perambulation, if accepted, would shift the tax bill year after. But the map, as we have it, that how you're taxing your people, how we're taxing ours, how Molten Borough is, that has been in compliance with the 1805 map. This perambulation that was presented to us takes the deviance from that. And I think,
In your opinion?
in our opinion,
Yeah,
and
just to be
there's-
clear,
But I would imagine
that's what's being debated.
Is there value for me to grab the map just to make sure we're all on the same page?
Oh, we've all looked at that.
Yeah, I mean, I think everybody's aware of it.
But I would imagine as a select board, it seems like with town obligations, there are often obligations that take up a large volume of time that don't necessarily pay dividends in terms of the value of your time put into it. I think the problem is fundamentally to say, yes, we agree to something that we know is incorrect. Once we know that it's incorrect, there's some obligation to actually say, no, actually, we believe this is
Well,
incorrect.
we might decide not to object to something that we know is going to cost us $100,000 and the tax implications are in the tens of dollars. We might just accept it.
That's
even
what
if we
you're
don't
doing.
think it's-
Sure.
Say again?
But that's what you're doing to contest our position.
Well, we didn't start this, you did.
Well, sure.
And our perfectly good surveyor doesn't agree with your perfectly good surveyor.
Well,
So-
there's more than that at play. And, I think we all recognize that there are sometimes interesting things that bring things forward. So, Mr. Nix didn't have an interest in this matter when he started this process, except he was retained to look at the information. And we were prepared, if this doesn't fall in. But it's a shift in the town line is what we believe. That isn't going to change. And certainly the cost of it is much higher. I will tell you, in our discussions, we never looked at it and said, well, we're going to gain X amount of tax income. That has not ever been part of our conversation. It is understanding what our authority is. That's ultimately what drove us. And I think we all do this in serving our community and making sometimes some hard decisions. And that certainly was one of them. And we went back and forth for a period of time. Caroline, you were seated for that. Adam was not. So we have some representation like each of you that was not part of this decision. And that's why I thought it was important that we have this opportunity to talk about it as a group without just the attorneys.
Yeah.
And what is at stake? And we have a history of good neighbors, we're mutual aid supporters. When you have a fire, we're responding. When we have a fire, you're responding. Our police cover for each other. There's a long, good relationship over this. And we certainly, it wasn't our intent to create a financial burden, but that issue, we all took those oaths that said we would do, to the best of our abilities, this job. And once it became, in our minds, clear to us, we had no choice but to pursue this. And we were hoping at that point that there would be a quick resolution. And that's maybe where I was delusional, because once council gets involved, I think this seemed to be a bit of a surprise to the Tamworth board. I don't know what correspondence you typically have with the town council. We'd like to know where they're spending their dollars. And
So,
and so, I guess we're a little confused how something reached a point of cost where you were so unaware of
Well,
it.
because we're so new. All of us here, we've been here for a year and a half.
Year and a half. And this bill came in January, and we're like,
and we talked to our own council, that's, you know, I don't know that that's relevant to this conversation, but,
Well, there's a point
we're
that
just
you
wondering
made.
why so much money's being thrown at it.
By all three communities.
Yeah.
For,
But really,
For that, it doesn't
the
seem
lawyers
that-
are really the only ones who are gaining anything. They're gaining big.
you feel you had no choice.
Correct.
Uh,
And
Well, to be
you
clear, communication was sent to both towns before the lawsuit engaged.
correct.
And then the response that we got, at least from, it seemed from both towns, was, I guess we have no choice but to go to court over it. And like you said, at that point, I distinctly remember a conversation about attempting to keep the expenses under $10,000, which we've far surpassed now. And I think that was naive, but also they were clear, you know, there is no way to predict how the expenses will be.
And at the time we made that decision, we did reach out to the then, I think it was a temporary town administrator in Waltonboro, who said he would discuss it with the board. It might have been before your election, John. And I did speak to the chair. I think they were in between town administrators at that point, Keith. It was certainly probably before you.
yeah.
And I spoke with the then chair of the Tamworth Select Board to say that we'd made this decision. And it wasn't that I was seeking either, permission or just to be aware that that was happening, that this was going to go forward. And we knew there would be a cost to it. We were hoping it wouldn't be, we tossed around $10,000 at the time, and then it was $12,000.
Well, I think at this point, between our two towns combined, it's at 50. I don't know what you're at.
We're about that.
Yeah, and so going forward, we just so don't want to put this on the taxpayers. Is there any way forward that, and that's the problem, is there's no compromise allowed.
If we're, in a sense, this is going to be resolved. It's going to be resolved by it's not an adjudicator, it's a term.
Litigator.
For the expert, for the judge that will be deciding this.
It's an expert judge. There's a term.
Yes,
I'm
there's a
forgetting it,
specific term. And we can't dismiss what is our belief that we had no choice. That presentation. And even going back, you read these histories and different parts, we're not discussing massive amounts of property, but we're discussing a significance in a role that we as a select board could not do in accepting that. And though previous select boards had, when it came to our attention and the discussion, and we went to, legal counsel obviously said this is a shift from where you are, and that began this process. And here we are. So I think, what is it that we would like to accomplish? I mean, Molten Borough is obviously a party. You are sharing counsel, I believe. Is that correct?
Yeah, both were drunk.
I'm sorry.
Both were drunk.
Yes. Charlie?
So you have to dumb this down for me to keep it straight in my head. So essentially, if we're at a point where we hire a surveyor to do this property relation at the beginning. They followed the deeds, did their thing, as the surveyor, was trained to do. Came up with this line that deviated from the line that had been agreed upon for many years previous. And this showed up, however, though, the first time in 2011.
There's a first reference that there was a
Reference that
concern.
there's something going
Yes.
on
Yes.
by the surveyor that did
Yes.
the variation at that time.
That's correct. And I believe that was the Tamworth surveyor.
And so now we're at a point where this time, when obviously the surveyor we all hired laid down this line that clearly deviates from what you folks refer to as the 1805 survey. And now we're at a point where you've also had your own surveyor who now is saying, no, the 1805 is correct and this deviation is not correct. Based on presumably deeds and.
A substantial amount of research.
Well, right, so in other words, not because the surveying equipment and the ability to shoot lines is gonna be the same,
No.
especially at this stage.
It was explained to us that, they were amazingly accurate in the 17. It's amazing how accurate they were. Not to the handheld GPS, so we
But
expect
they
some
were,
deviance.
yeah.
Not the deviance from the top to the bottom, not the bottom, but a very steep incline. There is a difference, and I think the other thing that became clear, Keats, is that we had documentation going into the, I'm going to say, the non-mediation deviation, at which we agreed on certain points that lead up to the line. And during the course of that meeting, the expert retained by Marlborough and Tamworth then put into question that, which was a new issue that had come up, which created additional costs because the expert came up with a different reasoning that was not priorly expressed. And that's why we had to do rebuttals, because we went into the meeting agreeing through points 1 through 5. And she shifted that during that presentation, which then there was a rule of no cross-examination. Each party had the opportunity to present their, and I will share with you, for those of us that were in there, it was a very lengthy presentation, probably too lengthy. But that became a question, and that resulted in these rebuttal statements, because the original presentation of where the digression was, she added more elements to that.
So I'm curious, was there a meeting when this first came up between the bodies without a lawsuit, or did it
There was
go?
a letter. There were letters that were sent to both boards.
Yeah. And then I did the personal reach out, as I said, to the chair and then the town administrator. I'm not sure where those conversations went.
I believe the letter asked for a meeting,
Correct.
but it was a long time ago.
And that was 2011?
No,
No,
No, that was 2021. Yeah.
I would have hoped that if we had all sat down at a table, we could have avoided $100,000 in legal bills, but I guess that's behind us.
I mean, the resolution is to come to agreement, but it has to be, what we'll call A or B. A being the original line, and B being the survey as presented. And I think,
We agree with that, we just don't agree which is
but
which.
understand that there will be, that's still not, that's not the tax bill. That's not the 1805 survey that we were required and was adopted by the legislature in 1805. That's defined us.
So, I'm new to this, so I'm not really understanding it all. But I'm not clear what line we're talking about. It was my understanding that the dispute was where the corner of Sandwich was, which is the boundary between
The final, Emma, thank you.
The dispute was where was that corner,
Yeah.
which is 900 some odd feet off the summit. That doesn't change the southern border of Sandwich or the northern border of Marlborough or intersect of Sandwich, right? We in agreement with that? So that line is not in dispute. What's in dispute is where is that corner, where is the border between Tamworth and Sandwich at that point?
Correct. Right.
And
Yes,
we're looking
multiple
at-
looks at it and says, would you two fight and leave our business?
If I look at what the dispute says, is actually, if it's moving that 900 feet this way, it's actually, from what I can see, actually taking land away from Marlborough. So I'm a little unclear as to why that is, that's being contested by Marlborough, but if in fact we agree that that point of the, what would it be, the southeastern point of Sandwich, which would be the southwestern point of Tamworth, what I'm not clear on is that shifting the line, or are we saying that the line is no longer straight? So what's your
That's part of the
position?
debate.
What?
That's one of the.
So, but I'm just wondering what your position is.
We happen to have a copy of the, actual, that's got the
Yeah.
Would it be helpful just to, so you guys can take this?
Yeah.
This was the handout that we received at the mediation.
So the one, it keeps a straight line, but then there's a much larger chunk that becomes Tamworth.
Right, and so the reason I'm confused about that position would be, is that that would change where, say, the border intersects with 25, for example, which is the main road north of that, right? Because if it doesn't change that, then if it's still a straight line, that border is no longer going to be where the monuments are at 25.
Yeah, if you look at that point, I think what you're saying in the bottom of that.
Right.
So it doesn't affect Boltonborough's land mass at all.
Yes.
It simply changes how much we share with Tamworth.
Yeah, I get that. So it doesn't actually,
It doesn't change Boltonborough at all.
but the intercept where there are is the intercept where Moultonborough hits Tamworth and Sandwich is shifted. Our position is that it's farther to the east,
Yes.
and yours is farther to the west, I believe, right? Okay, well, there's the map.
And I know,
So I guess one of my questions is, so you're maintaining it is a straight line, it's just the line is different than what is currently drawn on the maps?
that's as best as I understand it.
And Moultonborough's dog in the fight is simply, my understanding, and again, I'm the newest member this time to the board, is that we hired a surveyor, that's what our that we all agreed to hire and do the job. That's what they came up with, we had no reason to deviate.
It's a Paul King.
And we paid him to do it.
Well,
No, it's
Paul did many of the past ones. There was a new one on Cynthia's company. I don't know what that was. Yeah.
It was Lake Street survey.
Lakes Region Survey, which was separate.
Oh, that Moultonborough hired to do your whole.
We had to jointly hire.
Jointly.
That's why we're hiring.
And that's typically what's done.
So the crux of the dispute is, we maintain that it's the top of the mountain, and the monument that's in question here is 900 feet
To the west.
to the west. That's all what we're disagreeing on.
And that
Is it the monument or the top of the mountain?
And that happened over time, we agreed, and the line was to the top. And then, and it's not perfectly calculated in here. There's a reference point of decades ago that it shifted, and then that confirmation began at that point. So
And I do know that Steve Nix, in his research, found that the 2011 perambulation, I believe, was questioned at the time in the documentation, and it was not signed off by Sandwich at that time.
There was recent acknowledgement there was acknowledgement that there was a disagreement, but my understanding, at least my perception, is that the boards at the time did not want to go down this path.
They were smart.
And I was lucky.
So, again, I don't know that we can adjudicate this here.
Well, I mean,
But I was
agreeing on what I disagree
Well,
with.
I wanted to say that one of the reasons our board wanted to come was to just try to understand why, because we could not understand why. And what we've heard, is that you felt you had no choice. It's too bad, because the three towns are going to end up spending $300,000 to $400,000 on this thing for no, in my opinion, discernible benefit to anyone.
Well, I would, go ahead.
Help me understand.
Well, Harry's first.
So, I think, I'm not sure if this started when I got on the board or right before I got on the board, but I know we kind of continued it on. And I guess I didn't realize the cost that was going to be going along with this. But here we are. And if I had known in hindsight that this all was going to happen, I probably would have been dead against it from the beginning, because this seems kind of a little ridiculous in my eyes, but here we are. And so when we got it presented originally, that I can remember, it just seemed cut and dry that this is where the line was, and I couldn't understand why we were, I had thought we had agreed on it all along from like the 1820s or whatever it was. So I said, well, this seems pretty obvious, so we'll continue on with this, and then we'll get hit with a pretty hefty legal bill, and here we are sitting here tonight. So, and now I didn't realize that there was a issue in 2011. I just found it out now, I guess. So, yeah. Anyway.
And typically when we have work sessions, we don't have input from the public as well, but I would say half the time we probably relax that when there are people that have things to say, and you do have people who have appeared here. So if they have some things to say, I'd like to hear it.
My concern is that we have people with positions that others may not be here that have, we don't all have our experts here. So that's a concern in terms of this meeting. This was for our discussion.
Yeah, well, we don't have any experts here.
Right, and so you do not, but let's get a little more input and let's consider that. We have 15 more minutes to do this. I think that was concerned, and that's why we made this decision not to have public input on this matter, because it really comes down to us. And we've had a host of people presenting information. And either we can hopefully begin to look at a decision, or it reaches that point of a legal process. And we're confident that we will have a case that looks to our favor, or we wouldn't be doing this. As do you. But there is documentation that tells us that that shifted, not in 1805, but after that period. And we have notations starting in 2011 that there was a deviance. And even, it's sort of also makes sense when you understand where the point is on the side of the slope versus, and I remember it was a big discussion because they were referencing Ossipee Mountain, that's now Bald Knob, the Black Snout, but we know which mountain they were pointing to. And as I said, we've been through this. I think particularly the rebuttal statements that were necessary coming out of our earlier meeting really signified to me that even the expert, is it Dix? What's her name? Cynthia's last name?
Boyster.
That she had shifted and brought up points that we had not discussed prior. And that created these rebuttals. So that really prompted this opportunity for us to have a discussion on a shifting argument. It matters. It matters where our town lies.
So I'm wondering what your takeaway of the arbiter, the partial.
He has not produced a statement.
Right. My understanding is that, was it the preliminary?
Well, he had spoken to the attorneys after the meeting,
Okay.
stating that he thought it was too close to call.
Right. So
That's not what was conveyed to us, that he's still preparing a statement.
He was still working on it. I mean, I think our perception seemed to be that there was a lot of effort focused on almost like a criminal case, focusing on why our point didn't hold and less supporting why your point is the correct point. So that's why it seems like we're also confident that there's a lot of documentation to back up where we believe it to be, and some of the issues that were brought up really aren't relevant to that specific point.
And the other piece is, and you may remember this, Keith, because we were there, he did say, but select boards do not have the power to change a town line.
Yeah.
And that came back, and as we said, we feel there's a compelling evidence that our baseline of the original, I don't know where if you have it, Emily, that is the original one.
So we'll see what he says, and we can move on from that statement. I think in a moment ago, I was maybe too cavalierly saying that I don't see the benefit of this. And I think you were going to respond to that.
Well, it's the town line matrix, and our authority to arbitrarily make a shift of that town line from the originally accepted 1805 map. And as I said, in the beginning of this, we broke it down to simplicity. The other two can certainly speak to different points.
I think, if I'm able to say this, speak to that a little bit. I think that one of the problems with having the wonderful kind of democratic direct things that we have in our select boards is that the turnover is so high that over time, little things creep up, little things creep up. And a lot of times, our select boards, that's what we do, is say, let's not do that. So that begins together. And the problem is that if you have something like this that has been, that is drawn out on a legislative map in Congress or wherever, that we can agree to do whatever we want, but somewhere along the line, with some future select board, the same thing is going to come up and bite us in the ass. I suddenly came up in the language I almost did. So in a way, as much as we want to say it doesn't matter, it's not going to make a difference to anybody, it's not any money that anyone wants, not even land anyone cares about per se. You're not going to build condos on it or anything, and to my knowledge. It just becomes a matter of law and the way things are drawn. And just because we've all accepted that we're going to agree to keep on doing it a little slack here and a little slack there, doesn't mean we're doing it correctly. And I know that one thing that our board has dealt with, and probably your boards have done the same thing, is looking at things that past boards have done, and you just go, what? How did that get by? And then you have to go back and correct it, because someone has to. Otherwise, it just isn't going to be clean and legal and all of that. Someone's going to be able to question it. So that's kind of why we're here, is just to, we certainly didn't intend it to be costing this much. We thought, this is an anomaly, and this is the whole thing. Everybody spent a long time with it. We have a book like this thick with all of this history and pictures and circles and arrows and all that stuff. And it's laid out the way it's laid out. And somehow, over the years, we have just gradually drifted. And maybe it's as simple as somebody just didn't want to walk that last 900 feet straight up. People are people. I don't know how it happens, but that doesn't mean that it's correct.
So we have two arguing surveyors here.
Yeah.
Basically, right? Has anyone thought about hiring a third-party, completely impartial person from Canada that doesn't care about this?
That's kind of what the impartial judge is supposed to do.
But that he actually logged in survey?
No.
That's my point.
Fine, well, we did. So before I started, the tourism division came about, and the town of Baltimore went around to the neighboring communities around our border and said, we're going to hire a consultant to survey these land, right? Which we did, and then I literally had to write to everybody and say, I sent binders with the information. It said, do you accept this? And so I could file this letter with the state archives. And we did, except for Tanich, which is why we're here. And then we hired two other consultants. So essentially, when I go back to my board, hopefully this doesn't come across the wrong way, you want us to ask if they would accept your red, green line?
I was going to get to that. It seems to me we have, if we go to this arbiter and let the judge make a decision, say he sides with our original surveyor, then to your point, does the judge have the authority to reestablish that when he makes his decision, or does that then have to be approved by the state legislature?
That legal counsel is not in this room, so I don't have an answer to that.
Yeah, that's fine, I understand.
And I think
My understanding is the finding of fact. So the judge is ruling under it, the finding of fact, not.
Right, but if the finding of fact is that the line that has been on the tax map since 18, whatever it is, that it's wrong, and that what our surveyor that we just hired to do all this is correct, that's where we at.
I think the mediation, my understanding is that it's unbinding and non-binding. So anybody could object to that, if it doesn't go their way.
And it wasn't even mediation, it was sort of a non-legal, this is an unusual
It was
service.
a hearing.
It really, it's historic implications. I think that we're grateful for what I think has been a cordial conversation. I think we have some time before that's late to really look at some of these facts. And we have, all the town administrators are in this room, and that's really a key piece. And I think we can certainly take a fresh look at some things. We have a little bit of time, and perhaps have that conversation among the town administrators if we see anything coming out of this meeting. There's been some questions that we haven't been able to answer, and we have a clock ticking into September.
And I think we should have a response from the neutral observer this week, hopefully.
Yeah, which way?
Who knows what it'll say?
I did ask legal counsel, the neutral observer has not been paid because he's not produced a work product yet.
So was the assumption that if he leans to one way or the other, aside from completely obfuscating and saying not going to call, that that's what will be accepted?
Well, that's a decision that we would then have to make. If he came and said, you guys don't have a good case, they've got it, then we would probably say, well, we're not going to spend another $200,000 on this.
Yeah.
And vice versa, theoretically.
The hope was that this would be kind of a shortcut to say, yes, there's a definitive one way or the other.
Right.
That was the
That was
hope.
the hope.
And normally time, typically out of mediation, you get something, I don't know, 2 weeks, less than 2 weeks out of the meeting. This one, but as I said, there were some shifting of points that were brought up in that were not part of the original documentation. And that was those questions. So I think, again, we're grateful for your time, and we hopefully will continue this conversation.
And I'll repeat my interest in some public input. If you've got a meeting starting at 5, we've run out of time, but I think there may be landowners in the room who are affected by this, I don't know. But I think either right now or at a future date, we should have an opportunity for public.
We have about 5 minutes remaining. If we can keep points extremely succinct, how many people would like to speak to this matter? You had your hand first, just extremely brief, and then find yourself with the copy here, and thanks for running.
Yes, my name is Jackie Christie. I live in Lansing, and I'm a sandwich taxpayer. I would just like to say I appreciate that very much the select board's interest in serving the town. I want to say that I think the service of the town should incorporate all of the benefits, the larger benefits to the taxpayer, and not the simple adherence to one historical event or marker over another historical event or marker. But I'm concerned that there is no perceivable to me or no stated value of benefit of the line being drawn one way or another way to any of the 3 towns that are present here.
And you're not a property owner that's affected in this?
No, I am not. And I understand from what, although I didn't hear you answer the question that Mr. Doucette asked, whether the property owner had urged the town to resolve this issue in one way or another. As I understand it, the property owner has no interest in a decision one way or another.
There are multiple property owners.
But they're not the ones who are concerned with the outcome of what collectively is
I
decided.
would imagine that people are, but that wasn't decided.
But they've not stated it to the town.
Well, thank you. Nice to meet you. I believe, Chip, you raised your hand second, and then the gentleman.
I think what you're missing is that if you take, I'm Chip Kimball, Taylor Road, he owns about 1,000 acres that crosses Sandstone Pond, okay, in the area of what I'll call the original dispute, that is south of 125. I think what you're missing is that if you choose the line, the 900-foot off line that Tamworth is advocating, those people advocating, you're going to have to change the taxes, and people's land is going to shift from Sandwich to Tamworth, starting up in Lansing, all the way down with a line that gets wider and wider as you go, because the taxing now is on the straight line to the top. And as an example, I have a lot up there that Tamworth says is 30 acres. Okay. The so-called blue line that you might have seen in there, which was painted blue by the community school over Blazes. If you go out there and measure it from the blue line over into Tamworth, it's 60 acres. Okay. And that is, and actually that it's based on the latest thing from Cynthia, just right there. It's going to be even more because she moved it even more, it makes the whole thing straight. And to go back to 2006 or 7, I paid, believing that the blue line was right, I paid timber tax, about $500 to Tamworth, while I was paying real estate taxes on that piece of property, part of the property, to Sandwich, and yeah. So obviously that doesn't, $500 doesn't cover hundreds of thousands of dollars, but you're going to have to change everybody along the way if this comes.
Thank you.
I'm Paul King. I'm the one who did the work in 2011. And I just want to correct one misconception. Everybody keeps talking about straight lines. No town perambulated lines are straight lines. None of them any place. They all go from monument to monument to monument to monument. And every one of those is a zigzag. Some are very faint zigzags, some are a little bit bigger than you expect for it, and some more are faint. But you go from monument to monument, it's never a straight line.
Susan Bryant Kimball in Sandwich. I just point out that a perambulation is not a survey. Does not hold the rules. We're talking here about municipal boundaries, and there are different rules in municipal boundaries than private property. In particular, private property you can gain by acquiescence. You cannot change a municipal line by acquiescence. So the perambulation is different on that. And when Mr. King started the perambulation of 2011, that again was a 2011 perambulation. It didn't come to agreement. I was a member of that perambulation committee. I'm not a surveyor. Don't have to be a surveyor to be on the perambulation to do that. When we're talking about the 1805 map, that is a survey approved by the legislature. And in order for that to change, you have to have a judicial process or a legislative process. Neither is that. A perambulation will not change an established, a municipal line that has been established on the ground.
Thank you. We hit 5 o'clock. Thank you all for being here, for the input. So we have a little time that perhaps we can come to some sort of a process that takes potentially legal action off the table in the next coming weeks. Appreciate your time.